Good evening, gentlemen, ladies and gentlemen. My name is Sheldon Mycoo. I am from the Faculty of Law at St. Augustine, University of the West Indies. My question is a type of amalgamation, of two comments made earlier by Mr. Raymond and by Senior Counsel in the context of the dismantling of our institutions. Our democracy is based upon the rule of law, separation of powers, where the government, legislature, the judiciary, the executive, the roles and functions are, while they may overlap, it's supposed to be separate. My question is, in the context of the dismantling of the current legislation, as well as some of your concerns in your council with regards to the Privy Council as against the CCJ, over the last, I would say, I wouldn't want to go as far back as 4 years, but it could be before that as well. What we've seen is a serious blurring of the lines in terms of the separation of powers. And the judiciary appears to be severely compromised. You see it in the headlines every other day. How do we address those challenges, seeing that the judiciary is really the foundation upon which our democracy is built in terms of that being that check and balance against the actions of the executive and the legislature? How do we make the public aware of conceptually what our democracy was built on, and how can we come up with innovative strategies to take our democracy forward in the context of the balance of Caribbean jurisprudence as against decisions made in the Privy Council? How do we, in terms of your experience, how do we navigate those waters? It's a lot, eh?
It's a very sensitive area, and it's not easy for governments and people to deal with it. But if we go back in history a bit, when we were becoming a republic country, a lot of pressure was being put on Dr. Eric Williams, who had the requisite majority in the parliament, to get rid of the Privy Council as the final court of appeal. And he resisted it. And people were surprised he resisted it. And if you go back in history, he was asked, well, how it is you're going republic? It will be contrary to sovereignty and nationalism. And he said that, words to the effect, that justice is an international issue. It is important for people in a small society to believe that they get justice. And he said, words to the effect, everybody goes to cocktail parties in Trinidad and Tobago. And he would like to accede to the popular view of having the Privy Council as the final court of appeal. But that does not affect the sovereignty of Trinidad and Tobago. Now, when I was Attorney General, we had to decide a question also. And the question came as to whether we should break away from the Privy Council and have the Caribbean Court of Justice. I took the position, and I advised the government, that the concept of the Caribbean Court of Justice is a very good concept. But the issue of justice is not an issue for politicians. It's an issue for the people, and the public must have confidence in the administration of justice. So what we can do is that we can have a system that you build a confidence, and you have appeals from the Court of Appeal to the Court of Appeal. You have some appeals, and you still maintain some appeals to the Privy Council. And over a period of time, people would have confidence, and then you have a referendum for the people to decide whether you want to abolish the Privy Council or not. Now, I can tell you from the experience I have as a lawyer, I have the greatest respect for the judges of Trinidad and Tobago. I have a very good relationship with the president of the Caribbean Court of Justice. But when I take cases from Trinidad and the Caribbean, and some of these politically sensitive matters, and when the decision occurs in the Caribbean, and I get one type of result, and when I go to London in the Privy Council, and it's a completely detached court, I get a totally different results. And the results that I get in England are more in keeping with, generally more in keeping with promoting the rights of the individual, I cannot help but feel that something is radically wrong. So that is why recently I have embarked on a public education program to try and teach people about some of the important judgments that you have in the Caribbean and some that you have in England. For example, something that will affect parliamentary privilege. As a matter of fact, I told your lawyer about this 2 days ago,
Right.
Mr. Kingsley.
Yes.
I had a case in St. Vincent, the former commissioner of police, a man by the name of Randolph Toucey. The Prime Minister, Mr. Gonzalez, went to the Parliament and decided to acquire his land and give the reason in the Parliament because Mr. Toucey was opposed to him when he was opposition leader. So, in effect, what he said was, I'm acquiring the land not for public purpose, but to get personal revenge. So we filed a constitutional motion to set aside the acquisition. We applied for the transcript of the House of Representatives there. We put it in the court. Mr. Gonzalez's lawyer take the point that that is parliamentary privilege. It cannot be used by the court. The court cannot look at it. The court cannot see it. The court cannot rely upon it. I went to the High Court. The High Court judge disagreed with me. I went to the Court of Appeal. The Court of Appeal judge disagreed with me. I went to the Privy Council. The Privy Council decided parliamentary privilege was to protect the parliamentarian from not being sued for anything they said in court. But it's not to be used to suppress evidence to assist people to show that the Prime Minister was misbehaving and misconducting himself in the Parliament. Mr. Toucey then won his case, got compensation for his land. So without the Privy Council, Mr. Gonzalez would have been able to say what he wanted in the Parliament. We had another one just the other day. I think you would have seen it. A former Prime Minister of St. Vincent, Sir James Mitchell. Mr. Gonzalez appointed a commission of inquiry. And he was not, he didn't give any evidence as yet. And in the middle of the inquiry, the commissioner sends a secret report to the director of public prosecution, in effect asking for Mr. Mitchell to be locked up. I filed a motion saying, well, this commissioner is biased, and there's a former judge of the Court of Appeal in the Eastern Caribbean. He's biased. Went to the High Court. The High Court said, no, the fact that he did that, he's not biased. And I couldn't think of anything more biased than that. Went to the Court of Appeal, and I was amazed. After arguing it for days, they reserve a judgment, and they said they agree with the High Court. So James Mitchell wanted to know what is going on in St. Vincent. And there's a man who served the country in his own country, went to the Privy Council. Within 10 minutes, sitting in the Privy Council, he touched me. He said, Ramesh, this is a different place to St. Vincent. I get injustice. The Privy Council stopped the inquiry, said it's bias and etc. Quite recently in Trinidad, municipal police officers went to court. Government breached their rights. The High Court ordered, well, they should get damages. The Court of Appeals said, no damages because the damages are too speculative. So if your rights are violated, you suffer for 20 years violation, you're entitled to get some compensation. Went to England. The Privy Council decided, well, since 1800 and something, judges are deciding cases with damages, even if they are speculated. That's the function of the court. And they ordered the people to get damages. So I could go on and on. In 1975, I'm sorry that in 1975, I was a young lawyer.
Take notes.
I was a young lawyer, and a judge was doing injustice to my clients. I went before the judge. I said, my lord, you're guilty of unjudicial conduct. He said, contempt of court, 7 days simple imprisonment. The senator asked me to apologize. I said, no, tell the judge that I will ask for 14 days. I said, anyhow, to cut a long story short, courts in Trinidad and Tobago, no redress. The Privy Council, I got redress, and the decision was not even a judge could violate the Constitution, and the state is immune from liability. If the judge violates the Constitution, the state must pay.
I want to just come in on this question for a second. I will just come in on this question for a second, Mr. Tanku's question. I think it...
Mycoo.
Mycoo, I'm sorry.
Mr. Tanku is the Prime Minister's Secretary.
Okay. Okay, Mr. Mycoo. The question I want to come in on, I want to come at a different level from Mr. Ramesh Maraj. Ramesh Maraj was elucidating on the difference between the treatment of the Privy Council and the Caribbean Court of Justice. But I think you started off at a very interesting point, because we talk about the separation of powers question. And just this week, I was having a hard debate with a friend of mine about it. The separation of powers question is really like a kind of one of those urban myths. So we think we've seen it. And we all know somebody who saw it. But could anybody actually show you a photo of it, like the Loch Ness Monster? So we here in Trinidad and Tobago discussing the separation of powers. And we have the classic formula of the judiciary, the executive, and the legislature. And we discuss it like that, when we go to classics classes and we do university and so on and so on. But in our parliament, the way that things run in Trinidad and Tobago, just about, and certainly for the last 15 years or so, just about everybody who's a member of parliament for the government in power is a member of cabinet. So in fact, half of the legislature is in the executive. Right? Right or wrong? So what are we really talking about?
It's a fusion.
So it's a kind of mathematical question. When you get down to it and you write it down on a piece of paper, take a clean piece of paper and write it out. Or like new maths, when you do these things where the lines intersect and what is overlapping with what and thing. It really makes no kind of sense.
It's a fusion. It's not
yeah, it's a fusion. It's a kind of confusion. It really is like that. Yeah. So we don't have much separation, and you could witness it. So for instance, just to give an example, segueing on this point we're talking about FOI. We're talking about these integrity and transparency provisions in our law, because this is the kind of discussion we have in here this evening. I can remember very clearly. Let's give a date. Let's give a year, March of 2009. The Attorney General at the time was the PNM administration, was Bridget Anisa George. And that lady brought to Parliament, I don't know if the word is motion, but an amendment, a proposed amendment to the Integrity in Public Life Act. And the proposal was to make the Integrity in Public Life Act become the sort of act that, in fact, if you want to report wrongdoing by a public official, you have to give all your particulars, your name, your address, you have to put the statement in writing, you have to sign it. Yeah. Of course, there was a howls of protest to the point that some of the members of the opposition, who are now in government, had to be put out of Parliament. But that was a serious submission, or some of you may say, and the rationale it was put forward on was one of those flim-flam things where, in fact, you say that, in fact, if you don't do this, people are going to muddy people's names, and as a public official, you're going to be accused of corruption, and it's going to be out there, and you were accused of this, and you were accused of that, and people can just make anonymous reports about you. But then again, you pause and you say, what is crime line? What is 800 tips? When you could pick up the phone, if you look out of your window and see somebody locking somebody's neck on your street, and you could pick up the phone and report, hey, I'm seeing somebody locking a fella's neck across the street. And it's two guys in red T-shirts, or it's two guys in yellow T-shirts, or whatever color. And this is what's happening. And you could make an anonymous report of a violent crime. But we were being told in May 2009 that an anonymous report of white-collar crime was somehow of a tremendous threat to good order. So that was another attempt at dismantlement. It soon failed, because a number of us wrote about it and mashed it up. Fine. It soon failed. But you've got to be vigilant. Let's come back to the question about the civic society engagement. We've got to be vigilant to preserve the gains we have made in our country's framework.
I have a couple of questions.
I think Ola BC. Oh, sorry. I'm not sure.
You got a question? Yeah?
No, I'm not sure.
This one, yeah, and then we'll take you. Yeah?